Welcome back. Alabama Supreme Court delivers a groundbreaking verdict, officially acknowledging frozen embryos as legal entities tantamount to children. This landmark decision sparks fresh debate on matters concerning reproductive rights and ethical considerations in medical practice. What implications does this hold for the trajectory of infertility treatments and the vast inventory of frozen embryos housed nationwide? Joining us now is the Assistant Professor of Bioethics at Columbia School of Professional Studies, David N. Hoffman. David, thank you so much for joining me.
Pleasure to be with you.
Now, before we jump into the topic, I definitely want to learn a little bit more about you. Can you just tell us more about your role at Columbia School of Professional Studies?
Absolutely. I teach in the master's program in bioethics, where we also offer a certificate in bioethics for people who are not ready to commit to a full master's program. And I teach courses on, among other things, law and bioethics, organ transplantation ethics, organizational ethics, and clinical ethics at the end of life.
So this means that you're a perfect person to have this discussion on. So thank you again for joining us. I just want to start off by saying, the recent Alabama Supreme Court ruling classifies embryos as children under state law, and it has sparked a lot of debate. Can you just explain the core of this decision and its potential impact on IVF practices?
Absolutely. This is not a new development in Alabama. It is merely a new application of Alabama law that has existed since 1975. It was in that year that Alabama adopted the Wrongful Death of a Minor Act. And that law said that the death of an embryo could be the subject of a civil lawsuit, that is, a lawsuit to collect monetary damages, if the embryo died as a result of somebody else's fault or negligence. That could be a physician in a medical context. It could be the driver of an automobile that injured a pregnant woman, resulting in the loss of the pregnancy. And what the Alabama Supreme Court's decision in the case that is variously referred to as the LePage decision or the Fondy decision, it's the one that just came out recently, is to extend that statute or to interpret that statute to include embryos that exist outside of the female uterus. And that was a question that had not been directly addressed in the statute when it was adopted in 1975. All of these practices were at that point science fiction. And so what we have just recently is the extension of this wrongful death statute, this right to bring a civil claim, to include embryos that are in a woman's uterus, that is headed toward pregnancy and delivery of a newborn child, as well as embryos that are frozen and existing only outside of a woman's body.
Now, what are the potential consequences of this ruling for couples struggling with infertility who rely on IVF for family planning?
First thing everyone should know is that this law only applies in Alabama. So it has no direct legal implications for practices in New York or any other state, though it has certainly generated an enormous amount of discussion around the notion of liability for failure to properly care for frozen embryos and whether the notion of an embryo being frozen should be described using the same words in the English language as an embryo that is implanted in a woman's uterus. So the immediate impact in Alabama is it has IVF practitioners very nervous about their liability concerns, and that generated a response from the Alabama legislature because of the national outcry that the Supreme Court's interpretation of their wrongful death statute was going to have a chilling effect on availability of IVF services. And remember, IVF is for individuals who want to have a baby and can't. And the concern was that the Alabama Supreme Court decision would have a chilling effect on that. So the Alabama legislature hastily passed a law saying that individuals actually engaged in practices of in vitro fertilization would enjoy both civil and criminal immunity from liability. And that was some satisfaction to some practitioners in Alabama. Many others are still concerned about what the scope of the law will be, particularly because the LePage case, involved not the practice of IVF, the actual application of the technique, but rather it involved the negligent security around the frozen embryos. Somebody got into the storage facility, took some of the embryos, caused them to fall to the floor, and ultimately causing them to be non-viable, to not be available for implantation. That begs the question whether the Alabama statute, in response to the Alabama Supreme Court decision, is going to do enough to reassure practitioners of IVF to get involved in the full range of IVF activities. It's important for everyone to understand that right now, what has resumed is the implantation of already retrieved human eggs from the woman's ovaries, the fertilization of those eggs with male sperm, and then the freezing of them. What has resumed is the implantation of those frozen embryos. It remains to be seen whether the individuals who do IVF in Alabama will feel sufficiently comfortable to retrieve additional eggs from women's bodies, fertilize them, freeze them, and use them for future IVF attempts. And that's complicated because invariably, given the technology of IVF, a clinician who's providing IVF services is going to retrieve many more eggs than are needed or that could possibly be implanted. And the status, both the moral status and the legal status of those embryos, remains an open question in Alabama.
Now, from a bioethical standpoint, how does this ruling challenge our understanding of human life and personhood, particularly regarding embryos?
It's very interesting. Um, the bioethical question really turns on linguistics, right? What do we want to understand the word person or child to mean? And even what do we want to understand the notion of embryo to mean? Because there's one medically accepted definition that says a fertilized egg is not an embryo in a clinical sense until it is implanted inside of a uterus, because prior to implantation in a uterus, notwithstanding the existence of some new technologies that will dispense with the need for a human female uterus, ectogenesis, but putting that aside, the notion that the word uh, embryo and the notion of a child status being equivalent for an embryo that is frozen to that of an embryo that is implanted in a uterus creates communication and clarity problems that are the heart of the ethical dilemma, because we need to have a means, whatever we want, of describing the implanted embryo in a woman's uterus as being something different than a frozen embryo, which may or may not ever see the inside of anyone's uterus. And the ethical question is, who should decide when a frozen embryo goes inside of either the progenitor's uterus, the person who initiated the creation of the embryo, which may be their biologic material or the biological material of somebody else, but when does the progenitor get to decide this is the time for one or two or more of the frozen embryos to go inside some uterus? And of course, this question of personhood for for embryos getting inside of uteruses begs the question of the parenthood responsibility, right? Because that biologic material belongs to someone, and historically it has been the authority, legally and ethically, of that individual, that person whose biologic material is contained in the embryo, or that person who arranged for the creation of that embryo with perhaps two other people's biologic material, those individuals have exercised a parenthood right to decide whether those embryos should go into their uterus or anyone else's uterus. And that reality has now been called into question. Because when you assign personhood status to an embryo, frozen embryo, you're begging the question whether the progenitor, the person whose effort created that embryo, whether they have the legal and moral authority to decide when or if that embryo goes into a uterus or not.
Now, we have made it very clear that right now this is just in Alabama. However, do you think this ruling, in Alabama might influence discussions about IVF regulations in New York State?
Frankly, I think it will likely influence action in New York State, not in the manner in which either the Alabama legislature or the Alabama Supreme Court intended. Much of the discussion that has been prompted by the LePage decision of the Alabama Supreme Court has been directed towards strengthening protection for reproductive freedom and access to reproductive technology like IVF. Um, New York, for example, requires that all women have access to IVF services, and there is legislation currently being considered that would facilitate wider access to IVF services for more New Yorkers. So it's really had a galvanizing impact on states like New York that have historically been very supportive of IVF. In fact, our own Senator Kristen Gillibrand has introduced a piece of legislation in Congress to define the ability of individuals, couples, or single individuals to utilize IVF without fear of prosecution for the disposal or the decision not to implant any number of what we can describe as surplus embryos.
Now, more on a nationwide scale, how have healthcare providers, particularly IVF clinics, responded to pretty much everything that's going on in Alabama right now? I'm curious to know, what was the response to this ruling?
The response from the IVF clinical community, the practitioners, the doctors and therapists and technicians who are involved in providing IVF services, has been widely a reaction of great concern, simply because what Alabama did in reinterpreting their own wrongful death statute has raised discussions about taking similar steps in other states. And this is not, the Alabama case is not the beginning of this discussion. This discussion, in some respects, dates back to 1995, and the federal legislation and then litigation over partial birth abortion, which was the first attempt to identify legal protections and interests for an unborn fetus or child. And this has continued up to and including in recent years in states like Arizona that dramatically changed the law in that state with regard to who has control and responsibility for fertilized eggs, embryos, frozen embryos, in the case of divorce. So if anyone were interested, they could look at the case of Torres versus Terrell, which turned the settled law on this country on its head in deciding that the interests of the unimplanted embryos were paramount and subordinated the interests of the male and female progenitors, in this case, the couple that created the embryos with their biologic material, hence use of the term progenitor, and the disposition of those embryos when they decided to get divorced.
Now, I think this is a very interesting situation because, for the most part, This situation usually occurs when people want to have children and they want to have babies. Given your expertise, how do you perceive the intersection of reproductive rights and the pro-life movement in this ruling?
Well, this is a continuum, and we should be very clear about that. Regardless of how any of your viewers feel about IVF, and regardless of how they feel about abortion as a medical procedure, as a social controversy, and as a legal right, this is a continuum of development moving toward recognizing embryos now as early as the stage when they're still frozen, pre-implantation, as being the equivalent of a child who is extrauterine, outside of the uterus, meaning born. And it's all well and good for states to want to legislate on the topic of the moral status and the rights of frozen embryos. But using the term child or person to simultaneously describe the product of a pregnancy that is outside the uterus, where the umbilical cord has been cut, and that human organism is living and breathing on its own. We call that a baby. And using the same terms, person and child, to describe a frozen embryo just creates confusion about what the meaning of those words, person and child, are as we move from a tank full of frozen nitrogen to a living, breathing pink baby. That's intentional on the part of some people who want to use this notion of personhood as a way of undermining the notion, the doctrine that women should have the right to control what is done to their bodies. And this is a new controversy that we're going to have to deal with, specifically tied to this notion of a homonym, using a word to describe two different, even if they are related, phenomenon, such as child and person as a homonym being described as a term applied to frozen embryos and living, breathing pink babies.
Well, this is a very intense discussion, but I think it's something that definitely needs to happen. And it's been an ongoing fight in our country for such a long time. But I truly appreciate you, taking the time to come on our show and talk about it and educate our community a little bit more about what's going on, regardless of whatever side the person may fall on. There are some things that are, I guess, just factual in regard to a lot of this. So we truly appreciate you taking the time to kind of educate us and tell us what's going on. So thank you so much.
My pleasure.
We have to take a quick break. We'll be back after this.